I find he has great respect amongst everybody he's ever worked with. And I think we're very blessed to have him joining us here today. So Kent, thank you. And
You're welcome.
Kent and I discussed this. So many of us have become very adept at living within the Zoom world. If we had to teach classes, but for Kent, this is kind of a new world. And this class, he'll explain more about how he'll be doing it. So today may be a little bit of a test case in terms of how we navigate between the in-person and the Zoom world. It's a new world to Kent. So as we get everybody settled in, I will let you know that I've uploaded a copy of the purchase contract into the chat box. You need to take responsibility yourself here forward to make sure that you bring a copy of your contract and that you take notes. We sent it out to pretty much everybody that was joining us today. And if you're in person, there's copies there at the Market Center. Make sure you highlight, take notes, and be prepared. But for today, if you didn't get it and you need a copy, just put it in the chat box, either to the whole group or to me, and I will upload it again. Once you join Zoom after we start, the documents that were uploaded and the chat that occurred before you joined typically is not visible to you. So just let us know. And with that, I am going to be in the back seat here today, working from home, and I will turn it over. Kent, it's all yours.
Okay, thank you, Lisa. And thank you, everyone, especially you over Zoom for attending, for you in person for attending. As Lisa mentioned, I've been with the Ihara team now for many years. I don't do the negotiation role anymore. I stopped doing that about maybe 3 years ago or so, but I did do that for about maybe 5 years. So I've gone through the contract and presented the contract hundreds or thousands of times. So I understand it for the most part. I'm not a broker, right? I'm not a broker, but since I've worked with it a lot, I kind of do understand it. And we've done this a lot for our team, where we've gone through the contract, kind of explained it, discussed it, which I think a lot of the team members felt was very, very helpful. So offered it up to the Market Center through Lisa. Thanks, Lisa, for pouring back into the agents, and hope that you guys find this helpful for you as well. So the way that I would run the class is have the contract and we would take turns reading it. Okay, so that's kind of the format. So Lisa, for the guys that are on Zoom, I don't know if we should try and do that or just leave it for us here. What are your thoughts on that?
I think for today, let's start with the folks in the room, and I will engage with those in the chat box if anybody wants to participate, or if you're having difficulty hearing people in the room, then let's address it. But I think for today, let's start with the people in the room.
Okay, that makes sense.
We'll see how that works.
That makes sense, because I'm worried about the audio, right? Because if they're reading, then you may not hear. So it makes it a little bit more difficult. So,
and just as Kent told you, if you are reading, make sure you project and come up closer to the microphone. Carrie, will you point out where the uptake microphone is in the room? That will be helpful.
This is that?
Yep.
This is the only one.
Just speak up.
Okay, cool. So before we go further, I want to thank Carrie for helping me today. He's the big work with me on the Ihara team, and so it's always very comforting to have him here, because I know whenever things don't work, I look at him and it's fixed. So thank you, Carrie.
He just needs to be in the room and it starts working.
Yeah, exactly. So good luck, charm. So as agents, right, we get to go out on showings, we get to go look at open houses, we get to wear nice clothes. I'm not that I am, but you wear nice clothes and see nice homes, and that's a lot of fun stuff. Purchase contract, I don't know, a little different, right? Very tedious, very, very specific, or vague, depending. But I think that part of it is equally as important, right? You've probably gone through Bold, or if you haven't, highly encourage you to go to Bold.
Just started.
Perfect.
Yeah.
Because
It's Tuesday.
Yep. Next. Yeah.
I mean,
Great.
this contract, which I feel is super important in many aspects of working with your clients. But the key is you have to have clients. If you don't have clients, then honestly, what does this mean to you if you have no clients, right? It's kind of meaningless. So it helps you with developing that client relationship, and it definitely helps you when you get into contract and how to work with your clients. Okay, so let me see what else I have to share with you. So just real quick, why are you guys here? Why is this important to you?
Because this is the central point of what we do. If we don't know the contract, how are we going to master what we do for people and best serve them?
Agree? Anyone else?
And it's the legal part. Yeah, that is the important.
The legal
Because
part?
we don't-
Okay. But I have a broker, I have a coach.
So we feel confident in it.
Couldn't I just say, I don't really need to know this. I'll just call my broker. I'll just call my coach.
You're gonna explain to your clients. They will ask you questions.
Broker and coach are talking,
They're
they're
not
defined
gonna,
every
let me
day.
find my contract and pull it up.
Perfect. So understanding this is important. And having a coach and a broker is great, but that is not the tool that you need, right? They'll provide you with guidance, but you really need, the more that you know, like knowledge is power, the more that you know, the more successful you'll be, the better you're able to maneuver, the better you're able to protect your client, right? So good. Okay, so in the negotiation class, right, we talked a little bit about preparation. So that's how this ties in, right? It's being prepared to be able to talk to your clients, how to get into escrow. And then once you're in escrow, how to maneuver with your client, with the other agent, understanding the rules, understanding what your responsibilities are. And that is so important in being able to manage and have a successful escrow. So I'm not super active now, but fortunately, there's a client that called me, wanted to write an offer. We wrote it, got into escrow. And so later I can show you some of my best practices. I'm very paper-based, old school. So I have a copy of my contract and I write all my dates on there and just easy for me to reference, right? So those are some of the things that I do, but it's all based on the contract. And once you're in escrow, it doesn't matter what people say, right? It's like, what does it say in here? Okay. So today, what I want is active participation. The way I'll do it is we'll just start at the top and we'll work our way down. What I found is that you would think it'd be pretty quick to just read through this and get through the contract, but the value is in the discussion, right? We'll read it and we'll kind of discuss it. And so there are times when we can, like J1 as an example, that might take an hour just talking about J1 because there are so many different situations that come up. So we have this scheduled for several weeks out. Know that I'm hoping we can finish it within that time frame. Maybe not. So we'll just see how it goes. And it's really going to be dependent on how much questions and participation we have. Okay. Okay. So any questions so far? Yes.
A question about your job or when you were at the.
Yeah.
But like, is it a huge bulk once you get into for open process negotiation? So would you be there for every single negotiation or would they
On the listing side.
on the listing side?
Yeah.
Oh,
So my job was once we got onto the market, I would look at all the offers that came in and I would present the offers to the seller because it was a listing. And then from there, I would take it all the way to closing. So I needed to explain the differences in all the offers that come in, all the nuances, help guide them to decide which one they want to accept, if any at all. And then once accepted and in escrow, get it through closing.
even the small negotiations, like the buyer wants this.
Yeah, all of that, all of that, all of that.
So question, if the more you do something, the better you are at it, what would you say the average number of contracts you went through?
Oh. I thought about that before I came here, but I didn't think about it enough to give you a number on that, Carrie. Sorry. That's why I said hundreds or thousands. A lot. I mean, because I'd be doing this I'd be reviewing contracts weekly or every other week, and there'd be at least a couple contracts, at least, right? Some would have this is back in the, I don't know, 5 years ago or so, where we had a lot of, it was still a seller's market. It went like this and then came back up again. So now we're in a seller's market. Before we had a peak as well. So there were times when I would have 14 offers on a property and I'd have to go through each one of them. Yeah, and explain it to the seller. So, okay, so purchase contract, right? Standard, 14 pages long. I would say most don't read it end to end, but I would encourage all of you to do that, right? It's very important. So we'll start, I'll start, okay? I'll start at the top and I'll read up until section A. And then we're gonna go around the room and then we'll have you each read a provision, stop at the end of the sentence, because maybe there's something we're gonna talk about, and if not, we'll continue. And then we'll see how far we can get. We have till 3 o'clock today, right? And maybe we'll take a break because that's kind of long, 2 hours. So maybe at an hour or so, we'll take a break. Okay, and then we'll take a 5-minute break and come back. Okay, so at the top, purchase contract, Hawaii Association of Realtors, standard form. There's a release date, 2/19, a revised 2/19 for release 5/21. Okay, so first thing is, that for release 5/21, I think it's twice a year, right? They'll come up with a new version. So be aware, there's dates on this. So if you have the wrong contract and it already is not the current one and you read it all out, you're ready to go to have Chad sign off on it, and he looks at it, he goes, wrong form. Guess what? Start all over again. Okay, so important to know these things, right? Copyright and trademark notice, this copyrighted Hawaii Association of Realtors standard form is licensed for use under terms of the Hawaii Association of Realtors standard form license agreement located at blah, 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 blah. The use of this form is not intended to identify the real estate licensee as a realtor. Realtor is a registered collective membership mark, which may be used only for real estate licensees who are members of the National Association of Realtors and who subscribe to its code of ethics. Okay, so this is for realtors, right? Up top, you have reviewed by. So you have Chad, or how many reviewers do we have now? Several. Oh, Lisa, yeah. Tony still reviews. Tony reviews. Okay, and Joe. Okay. So you know how that works, right? So you'll put in who the PV is and then send it to them for signature along with the brokerage firm. Reference date. So the reference date is a date typically that you're either writing it or you're going to have the client sign off on. And Lisa, chime in, right? But I think the reference date, let's say that I write it today. I get Lisa to sign off today or tomorrow, and then the client to sign off tomorrow. I think that's okay. Is that right, Lisa? For the reference date?
I like to do the reference date is when the client's going to sign it, and hopefully, the BIC is signing it the same day as the client. In this virtual world, we've been able to do that, but otherwise, the reference date I think should be the date that the client signs it.
So I always try to do that as well. But if the date slips, does that have to be redated, or is the reference date okay?
I think it's fine. I think it's form over substance.
Yeah.
It's the only contract I've ever seen. Hawaii does things very differently than I'm used to. Typically a contract date is the date of ratification, but we use a reference date from when it's a starting point. It really is only meant to use as reference, so we know we're talking about the right document. So as long as you're matching them up, it's fine. But
Okay.
it should be first thing, try to make it the date your client's going to sign it. If they're signing it and you want to change it and initial it, at the same time and have them initial it, that's not going to be a problem. It's not going to change the enforceability of it.
Okay, you guys all got that? Okay. Property reference or address. So typically you're gonna pull that from MLS or TMK, right? And then tax map key. And when I'm going over contracts with buyers or sellers, I'm going over this information as well. And I use that as a way to double check that I put down the right address and that I put down the right TMK, right? Because unless it auto populates and you have it incorrectly in zip forms or whatever, I just always want to double check, okay? So in big bold, so what does that mean? Big bold, right? It's important. So this purchase contract becomes a legally binding contract for the purchase of real estate upon execution by the parties. So whoever is on there got to sign, right? Read it carefully. Handwritten or typed provisions in this purchase contract shall supersede any printed provisions if there is a conflict. What does that mean? So let's say that you have a provision in here that's part of the contract, right? And then you, in special provisions, section Q, you type something else up there and it conflicts with what the standard contract says.
Q controls,
What controls?
Q. Because it was written
The Q, right?
Yes.
Exactly. So if you were to say, well, you know, J1 says this, how come it doesn't apply? Well, it's because in section Q, you said waiving J1. And that's maybe not the best example because you never wanted to waive J1. But as an example, right? I waived it. So you wrote that in there and that took precedence over the contract that says J1 and these are your rights under J1. Okay, make sense? Okay. Fill in all blanks. Wait. Fill in all blanks. Paragraphs preceded by checkoff boxes are optional and must be checked to be made part of this purchase contract. Okay, super important. There are provisions in here that look in section H, right? They're all check boxes. So let's say that you don't check the boxes, but you fill out everything else. What happens? I filled it out. I didn't check the box. What happens?
They
Doesn't
likely
count.
don't apply.
Don't apply. That's what it's saying, right? Paragraphs preceded by checkoff boxes are optional and must be checked to be made part of the purchase contract. Must be checked to be made part of the purchase contract. I made that mistake. Luckily, the broker caught it, but I filled out a section. I didn't check the box. That's a problem. So it got sent back to me going, oh, are you not trying to include all the inclusions? Because I think that was the one that I didn't check off. So I put in there washer, dryer, air conditioning, smoke detector, but I didn't check the box under E2. So if it went out that way, buyer sign, broker sign went to the seller, and I was the buyer, the seller could say, oh, I get to keep everything because they didn't make it a part of the contract, right? So understand what that means. Write NA if not applicable. Yeah, and know that some of those sections, if you read it carefully, it'll say check A or B or 1 or 2 or this or that. I've seen contracts that come over where I think it was section N, like at closing or subject to rental agreements. They said NA for both, or they check both boxes, so it's the attention to detail that's really important.
Super random, but NA versus none, like I know the meaning, like that they're different, but like for Q1 or something, like if you write NA, is that wrong?
If you write NA, so explain, what are you writing in Q1?
Like if there's no Q1.
And it's just.
Oh, it's just, you want to leave it blank? Yeah, so they're doing that for clarity.
NA.
If you don't add anything in there, then there's nothing. some will put it in there just to be clear. There are no Q special terms.
Oh, okay. I was just wondering if the term NA or none is like.
Not applicable, yeah, or none. Yeah, so if, I've seen it where they'll submit an offer and in section Q, they'll just type in none. And they're just trying to tell you, I have no special provisions. That's all. Yeah. Okay.
Hey, can I chat in, Kent?
Yeah.
Chime in. So I'm pretty on it with them about, sometimes there are differences between none and not applicable.
Got
And
it.
in some cases, either is fine. Like in Q, I think either is fine. But if it's like M1 and you say not applicable on those blank lines, that could be problematic because you're saying that there are no other documents that are applicable. And I think even none, I like, I mean, read the paragraph. And this is the point of why we're doing this, is really to read and understand.
Yep.
And then think of the difference between none is, are there none or is it not applicable? So
Yeah.
Q could be either, but in some cases, and in that same vein, I'm going to chime in that there's a tool in Zip Forms that says fill everything with NA. And I would recommend you don't use that because it fills absolutely everything and that can cause a problem. So don't use that tool.
Oh, that's dangerous.
It is. And two other quick things. So this is a quirk that I think Chad and I both have, which is TMK numbers. There is a format for a TMK, and because of the digital world and how numbers work in a digital world, like in HIS or in the MLS, it will delete leading zeros, but
Oh.
the TMK number still has those zeros. So make sure your format for TMK is correct. So it's 1 digit for division, 1 digit for zone, 1 digit for section, 3 for plat, 3 for parcel. And if it's not a CPR, you don't need it, but otherwise the CPA is 4 digits. So, it's easy to fix that when it imports in. That should be the first thing you do. And then I'm going to tell you a quick tale of multiple offers. So one of our agents had 4 offers on a property. We were analyzing them yesterday. And out of the 4 offers, one agent dropped out of competition for 2 reasons. Number one, because they left a lot of things blank that shouldn't have been blank. So they didn't follow even the pre-printed instructions. And the second thing is how they sent the document over instead of attachments to the email. They sent them from, I can't remember if it was a OneDrive account in 2 separate pieces, and it made it very difficult to navigate. Then on top of that, their price was just competitive with the other offers. It didn't stand out. So there was no reason to go to extra work for an agent that was sloppy and disrespectful of the listing agent's time. So out of those 4 offers, without even knowing it, buyer number 4 lost being in the running with the other 3 because of the poor performance of their agent in being detail oriented and thorough in writing their offer. So that's why these kinds of conversations can make or break the difference in you having another bite at the apple.
Perfect, Lisa. That's great feedback. And I'll tell you that when we review contracts on the listing side, we absolutely will discount guys that submit offers that are sloppy. And it could be maybe because it's handwritten, hard to read. Maybe it's because they missed checking boxes, even though you know that it should be checked, it's not checked. It tells you either they're new, which may not be a good thing, or sloppy. Either way, it could lead to problems, right? And so understand, I think I talked about this at the negotiation class. When you get into escrow with somebody, you're living with them for at least 30, maybe 45 days. So if you can't even get a good contract from the beginning, be aware. That's what you're going to be dealing with for the next 30 to 45 days.
The sad thing is the broker signs off on it.
I'm sorry?
The bad thing or sad thing is the broker signs off on it.
We've got so many agents, we've got so many brokerage firms, and we have some that, will want to spend time with agents and will want to have agents well equipped. And unfortunately, you have others that all they want is a desk fee or whatever, however they make their money. So yeah, I'd rather be here. And then to Lisa's point about it matters when you use none and NA. Sorry, Lisa, I didn't realize where that question was going, but absolutely. You need to understand how to use NA or none appropriately, right? Because it could be a problem if you don't use it appropriately. Okay. Okay, so I'm gonna start this way and we're gonna work this way. So I'm sorry, your name is
Marinda.
Miranda. As soon as you bit something, then I'd call you, right? So can you start with section A?
Sure. A1, agency. Buyer and or seller in a real estate transaction in Hawaii may retain a real estate brokerage firm as their agent. In such case, buyer and or seller is represented by the brokerage firm and all of its licensees. Hawaii law requires real estate licensees to disclose orally or in writing to seller and or buyer whom the licensee represents. The form of representation may be one of the following.
Okay, hold on 1 second. So agency, right? We're agents and we work for KW. But the relationship is between the client and the brokerage, right? That's really the relationship. So it's important for clients to understand that we are helping to represent, but it's really the relationship is between the brokerage and the client. And that's why sometimes understanding that makes more sense when you start to talk about multiple offers or offers being, when you sign a listing agreement, would you consider a dual agency offer? And it's because, at KW, we have hundreds of agents. So if they say no to not dual agency, same agency, right? So I'm going to be the lister as a KW agent and a buyer comes in. Mr. Seller, are you okay if the buyer comes in from KW as well? And it's because it's agency based, right? It may be me as the seller and it may be you as the buyer's agent, but that's why it sounds a little confusing, but if you understand the agency relationship, that's where it comes into play, okay? So go ahead, you can continue.
So, A, seller's agent. Brokerage firm represents seller only represents seller only unless a disclosed dual agency
Dual
exists.
agency, yep.
Seller's agent owes the highest duties to the seller, including confidentiality, loyalty, and due care and diligence.
Okay, so that's where I was talking about dual agency, right? So it could be that two different agents are being representing the transaction. One KW agent as the seller's agent, one KW agent as the buyer's agent. Just because the agents are different doesn't matter. It's still a dual agency. You guys understand that? Okay. Okay, you can go ahead.
E, buyer's agent. Brokerage firm represents buyer only unless a disclosed dual agency exists. Buyer's agent owes the highest duties to buyer, including confidentiality, loyalty, and due care and diligence.
Okay, so there is a dual agency addendum. So if you're ever curious about what that means, read that. It's really important to understand that. So if it's a KW to KW transaction, right? It's good to understand that. Okay.
C, dual agent. Brokerage firm represents both buyer and seller. This commonly occurs when licensees in the brokerage firm representing seller and buyer clients looking for types of property similar to the seller's property. In such event, the brokerage firm and all of its licensees represent both buyer and seller are dual agents. Dual agents must remain neutral in negotiations and must not advance the interest of one party over the other. Written consent is required under Hawaii law. CRR 221, dual agency consent addendum.
Yeah, so that's important to read and understand. It's a little tricky. So there's situations where you have dual agency, different agents. Other situations where you have dual agency, same agent. Some agents are okay doing that, where they have representation of buyer and seller. Other agents will say, no, I'm not going to do that because I have a hard time separating the two. I'm in the middle of everything and I don't know how to manage expectations on both sides. It's very, very tricky if you're doing dual agency, dual agent. Not a lot. It happens though. I mean, I've done them before. It can be very tricky. You got to know your stuff and you got to be able to set expectations. Because the minute one feels that they're not being treated as fairly as the other, all hell can break loose. Yeah. So
They can sue you, right? Because they're not being
you can be sued for anything.
true.
Yeah. So what I say is you don't even have to be wrong and you can be sued. Just the perception will sue you. And you don't want to go through that. You don't want to go through arbitration or mediation. It's not fun. Yeah. Okay. Okay. And then D?
D,
Yep.
no agency representation, buyer or seller is a customer. See paragraph 8.2 below.
Okay. Okay. Any questions on that so far? Okay. Then I'll have you read next.
A2, disclosure. In our code of ethics, buyer and seller are aware that the National Association of Realtors holds its members accountable for their actions through a strict professional code of ethics, which includes a grievance system to address complaints. Non-members are held to the same standards as members, but are not held to the same standards as members, nor are they required to participate in the grievance system.
Okay. You can continue.
Seller representation. Seller is represented by the brokerage firm, Keller Williams, and its licensees.
Yep.
Brokerage firm is, check, a member of the National Association of Realtors.
Okay.
Buyer, did you want me to?
Yeah, keep going. Just go all the way down.
Buyer's representation. Buyer is represented by the brokerage firm and all its licensees. Brokerage firm is a member of National Association of Realtors. Dual agency representation. Seller and buyer are represented by the brokerage firm and all its licensees. Brokerage firm is a member of the National Association of Realtors. A separate dual agency consent addendum is required.
Okay, so why don't you stop there? So you're going to identify, right, who is representing who when you submit your offer. So it'll be, locations represent seller, buyers represented by Keller Williams, and you also identify, are they non-members or not? Check that off. And then if it's a dual agency, you check that off and then make sure that you have a separate dual agency consent addendum.
So since we have choices there, let's say we have seller by one, buyer by another.
Yeah.
The dual agency, are we just leaving it blank or do we have to put NA in it?
If you go with number C as an example,
Yeah.
so you go C, KW is a member.
No, I know, but to the left of the C where you have the,
Oh, yeah, AB would be NA, and then C would be,
I just wanted to make
X,
sure.
yeah.
Check.
Yeah.
Okay,
and then Lisa, correct me if I'm saying anything inconsistent with what you want.
Yep, all good.
Okay,
okay. D, customer, no agency representation. Seller is not represented by a brokerage firm, buyer is not represented by a brokerage.
okay, stop there. So let's say that you have a listing and somebody comes in and says, oh, I'm not going to be represented. Just write it up and then I'll sign. And they, then you go, okay. Under D, you check it and you go buyer, not represented by brokerage. You X that. You get into escrow. Buyer's not doing what you normally expect the buyer's agents to do when you do your transactions. What do? Like, they're not calling you for J1. They're not responding to stuff. What do? Do you advise them? Do you tell them what to do?
Tell the sellers?
The buyer, because you're representing seller.
Oh,
Are you telling buyer what they should be doing? Why?
because you don't have a contract.
Yeah, that's correct. I mean, they're saying they're a customer, they're not being represented. And you might be a nice person saying, oh, well, I'll help you out. But understand that I think that if you help them out, they may pull you in as you giving them advice, even though, yeah. So just
Would
be careful.
Would it
about that.
become a dual agency at that point? Like an unrecorded dual agency?
I think their claim would be that. I think their claim would be that, hey, you're giving me advice, almost like a dual agent, although the contract doesn't say that. But if they were to complain, that probably would be the basis for the complaint. Almost like a dual agent, right? Even though I said I'm a customer, you are providing me with guidance, almost like you're representing me, and I'm not happy with what you told me to do, and so I'm going to sue you now. So
Oh,
yeah,
okay.
so I would say that it's clearly not on the contract, but your actions may lead them to feel that way and then have a problem with it later. What about you, Lisa? What do you think?
I have to get to my unmute button pretty fast. Yeah, in Hawaii, if this is signed and you don't go overboard, you're protected by the writing. But I think you have to learn to say the right things and remember to say, I'm not your client. I can tell you my seller is looking for this, or you're not my client. My seller is looking for this, instead of giving advice. But being an undisclosed dual agent is a critical problem. And if you're dealing with people that are more litigation crazy, it's even more problematic. California doesn't allow customer relationships. So you have a lot more protection in Hawaii by even having this stated customer relationship than you would in other states. But also recognize that we deal with a lot of people from the mainland, and they may be used to different rules of conduct and different laws. And, just like Kit said earlier, you can get sued over anything. It doesn't mean it's righteous. So it's important to understand how to frame these things when you talk to people, so it doesn't even creep into their mind. I don't
Thank you,
know
Lisa.
if that helps clarify.
Yeah,
it.
no, absolutely. Just be cautious, right?
How does for sale by owner do it? Do they just not do contracts? Or they go?
I've not done one, but my guess is that you write it up and then you send it over to them. That's my guess. I don't know. I have no experience with
Yeah,
physical.
and I think we have a form for that, and the seller would be a customer. So that
Yeah.
is a for sale by owner. And you'll
Yeah.
even see it says that seller's not represented brokered by a brokerage firm, for example, for sale by owner.
Yeah. I just be leery because if agents have a hard time with this, would a FISBO know any of this, right? It'd be scary to me. Okay. You can continue. Why don't you read to the bottom of the page?
Okay. Buyer and seller acknowledged that oral or written disclosure relative to agency representation was provided to them before the signing of this purchase contract. It is recommended that buyers and sellers consult with legal counsel prior to signing the purchase contract. Initials below are for the agency disclosure acknowledgement and page 1 review.
Okay. So just letting them know, hey, we went over this. I've told you that our brokerage represents you, Mr. Buyer, Mr. Seller. It says, feel free to consult an attorney prior to signing this, and that by initialing below, you're acknowledging the agency disclosure. Okay.
Just also touching on having the buyer representation agreement signed with what it just said.
Oh. I don't think so.
This says oral or written disclosure relative to agency representation was provided to them before the purchase contract was signed. So that's leads me to believe that.
Yeah, I mean,
in reference to.
Yeah, it could be for the written disclosure. Yeah, that
Yes.
you have a buyer's rep signed, right?
Mhm.
Or at least you've explained to them what the relationship is that we have before you sign this.
Yeah, the other thing to remember is that's one of the major reasons we have the KW standard addendum. So, it's important, I think, have that KW standard addendum as part of your intake when you do a buyer consult, as one of the tools you use to help them understand. You end up communicating to them that you care about detail and you care about them understanding your relationship. So that's another disclosure document. But I think in this point, Brenda, that it's looking at, they're acknowledging the language above in A, B, and C.
Yeah. Okay. Okay. I'm sorry. Can you start? Why don't you read B and C?
Section B, initial earnest money deposit. A1, initial earnest money deposit. Buyer's initial earnest money deposit shall be processed as follows. Choose one. Buyer's agent has received a check from buyer which shall be deposited with escrow by the next business day after the acceptance date, or buyer shall directly deliver a check to escrow by the next business day after the acceptance date, or buyer shall wire the initial deposit into escrow account. Escrow the account within business days after the acceptance date.
Okay, stop there. So Lisa, is there like a KW best practice that you share in terms of which one of these three is recommended?
Hang on, am I still on mute? Am I? Oh, yeah, where I'm not muted. Okay. I think it's important to understand that if the client is going to deliver it, that then you can follow that. But, you know, think of to answer your question is there's not a single best practice except if you are going to get the check and deliver it, or if it says that you've received a check, make sure that that's truthful. So if you're going to get the check and deliver it instead of the agent, then clarify that in section Q. I think it makes sense to deal with the wiring and to give plenty of time so that they can get to the bank, order the wire and trigger the wire. I think you ought to give your client a decision in this. I have clients that don't know how to wire. Have this conversation with them.
Yeah. Okay, so my personal opinion is anytime there's something that we can help to control and the client's okay with that, then I kind of lean towards that route. What I mean is, if it's an older client and you know that they have a checking account or they're very used to writing checks, then it may be appropriate to say, when we meet and we find something and we start talking about writing an offer, part of it is an initial earnest money deposit. So bring your checkbook, because if we find a property that we want to write on, if you write me the check, not made out to me, but made out to escrow, I can take that and I can hold it so that when it's accepted, or if it's accepted, I'll run it over to escrow right away. And the reason I say that is because either they can give you that check and you can give it back if it doesn't get into escrow, or you can destroy it, versus them taking it into escrow. Let's say that you have an acceptance, right? Like, yay, good news, we're accepted. It was very competitive. You tell them, go deliver the check by tomorrow, close of business. And tomorrow they're just like hammered at work and they forget. What happened? What can happen to their offer?
Seller can back out, right?
Seller can back out because it says right there that you got to deposit it next business day.
But like a lot of things, like this happened last time too, and like a few days ago, but like we would go into acceptance. They would say they accepted, and then for the first one, the escrow company they chose, she got like she was gone for like a week, and we never got.
Who's she?
The escrow officer.
Which company is this?
Older Public.
Doesn't matter. You get okay. Okay, I got that. You want me to answer it now on that one?
Like, because it says from acceptance date,
Right. Right. Okay, so if you give the check to Old Republic, and let's say it's the Kailua office and it's John Smith. John Smith's on vacation till next month. So you go, oh, I have the check, but John's on vacation, but I'm going to drop it off to the downtown office. What's the difference? Is it the same? Okay, so when you said that the person is not available, it should not, your earnest money deposit should not be dependent on the escrow officer being available.
What if it's wiring though? What if you need a welcome package to get like the wire information?
If it's wiring, you got to prearrange it with the escrow company to get the information as to where to wire.
So even you can ask that before the escrow is even open?
Yeah.
Oh.
Yeah. Well, yeah, you're gonna open it and then you're gonna have to wire it over. So I personally haven't had clients wire in earnest money deposits. I'll either have them deliver a check if they want to deliver it, or I'll deliver it for them. If it's wiring, and let's say you haven't opened escrow yet, I mean, anyone anyone know what happens if you don't open escrow? I think you can still wire it, but I may be wrong. Lisa, do you know?
I'm sorry, say that again?
If, let's say we have an acceptance of an offer today. Client wants to wire the money tomorrow, but both buy and sell side, no one has sent over the documents to open escrow yet. Or they don't send it until like 2 p.m. and the client wants to wire it over at 8 a.m. But escrow has no idea that this offer has been accepted. So can that be done? Can you wire into escrow even though escrow has not been opened yet?
No, I don't believe you can because
Okay.
they need to have a reference.
Reference,
And,
okay.
you know, most of these wires are going into large accounts that they may not
Okay.
even know enough information. I mean, theoretically you could, but here's the other bigger concern that I have. A couple big concerns. Number one, never place yourself in the path of giving wiring instructions to your client, putting yourself between escrow and not. Now, when Kent and I started in the business, this wasn't an issue. But what's happened is we've had large cases across the country where bad guys get into your email account, or they pretend to have gotten into your email account. They get this information one way or another, and they start sending different wiring instructions. You can end up, because you insert yourself in the middle of this, to be the recipient of a very large lawsuit. The largest one I dealt with on the mainland was $1 million that had been co-opted. So keep yourself as a business practice out of the wiring instructions phase. Put them in touch directly with the escrow officer. So what I would say, if you find yourself in that situation, call the escrow officer. You're representing the buyer. Call the escrow officer and then say, can you call my client and figure out a way for them to get their funds in? So here's the real lesson in this is, don't allow anybody else to be your excuse for not following the contract. The contract is your roadmap. So if your TC isn't available, go ahead and open escrow. Don't go, well, my TM wasn't available, so I couldn't do it. Yes, you can. Talk to the other agent, open escrow, and then give the information to your TC or your TM. You know, so this is what we do. The detail is important.
Yeah, excellent. So acceptance, amount of days within acceptance, Lisa, what would be a good time frame for that under B1
For the wiring?
Yeah,
I like 2 business days. I like business days all day, anytime it requires performance, and when the other participants can't work or don't work on holidays and weekends. So I always use business days. And I think you want to give yourself at least 2 days, because anything can happen. That's why I don't like the section that says automatically 1 day. It's fine if you have the check in hand, but then the way it's worded doesn't say that you have it in hand. It says the client's going to deliver it. So, and by the way, you can change that. You can line out and put 2 days. You can put it in section Q. So this pre-printed language, again, we talked about that in the first phase. You can alter these things. They're not set in stone. So you could use DocuSign. You could use the line through tool in zip forms. You can hand do it and have your clients initial it. And you can change the number of days in that delivering a check. You can either put in, I've seen some brokers put in section Q that regarding that section, it's the buyer's agent or the buyer will deliver the check within X number of days or X number of business days. So you can do that as well.
Okay, good. Yeah, so give yourself time if you know that they want to wire, give yourself some time. I'm sorry.
I have a general question.
Yeah.
I'm still trying to understand the whole transaction process.
Yeah.
So where exactly is the agent going over all of this with their client? At what point in that?
For me, it's before you even submit the offer. So you're going over what the client is going to be held to, right? So we're gonna write an offer on a property. So Mr. Client, besides price, which is probably the easiest thing to figure out, right? Look at the comps, figure out what offer price you want to submit. Besides price, all the terms, because that's what you're going to follow. That's going to be your Bible for 30 to 45 days. So you're going through similarly to what we're doing today. You're going through the contract with the buyer or the seller. If you're receiving an offer, explaining what all this means.
So if you're getting 15 offers, you got to go over every single one with your client.
Yeah. Now, if it's 15 and, 5 of them are above asking and 10 are below asking, then you might go through them a lot quicker, the ones below asking, and then focus on the ones that you think have the best shot.
Okay, thank you.
But yeah, I mean, because I don't know of anyone, including myself, that would want to go through 14 offers, provision by provision. So,
I got a question.
yeah.
I know some of us, recently did our license exam. And one of the things in the class was you can't hold a check.
You cannot hold
You
it.
cannot hold a check. So is that just once you're in a contract? Like, because you said you get it beforehand in case it gets accepted. So
Yeah,
is that,
I'm going to have Lisa answer that question. So Lisa, the question is, they were told that you cannot hold a check for a client because prior to getting acceptance, I guess, right?
Yeah, this is interesting. I'm gonna plead a little bit of ignorance on this because of business practice versus law. The issue of holding a check is it becomes in most states known as trust fund handling. And I believe that, I'd have to go back to my first licensing years ago instead of my newer license. But we don't want agents holding on to funds because they can be deemed trust funds. In California, anyway, we have to log those in. Kent, did we used to take funds and hold on to them and keep trust fund logs?
We would just hold them, but it's old. I'm thinking more old school, right? We just hold
well,
them.
that's what I'm wondering, if it only matters once it's in contract.
So,
Well, explain, why would you be holding on to their check anyway?
because I would meet with them, have them sign an offer, submit it to the seller's agent, and if it was accepted, I would deposit it into escrow. If it wasn't accepted, then I would either return the check or just destroy it.
Yeah.
But I have it so that I can get it into escrow on time.
So here's what I'll say is, clearly you are able to hold on to the check or HAR and HBR wouldn't have put this into the contract. So it says you've received a check from the buyer. So you can hold on to it.
Yeah, I mean, going back to when I first started, what agents would do is they get the check, they would scan the check and submit it with the offer,
Yeah, that's old school.
Showing-
I'll do that.
showing that we had a deposit from the buyer. And you'd black out, obviously, you'd black out the account numbers and stuff.
Oh, we used
right?
to not black out the account numbers. When I
I
first
wasn't
started.
going to say that, Lisa, but yeah.
Yeah, well, in California, but that's how the world has changed. And the
Yeah.
viewpoint, it wasn't law. So here's the context of law, right? Is to have an enforceable contract, you have to have consideration. For probably the first 30 years of having a license, both in Hawaii and California, I would hear people argue that you had to have an initial earnest money deposit as consideration, or you didn't have an enforceable contract. So
Okay,
one
makes
night I'm
sense.
sitting with a bunch of California attorneys, maybe drinking, because I love drinking with attorneys, and seeing if I can, stump the attorney. And I said, do you need an earnest money deposit to make the contract enforceable? And one of them said, of course you do. And the other one said, why do you ask that? And I said, because the consideration is the promise to give the property in exchange for the promise to pay a certain price. So I don't believe you do. And there are 3 attorneys. And after I said that, they both went, that's interesting. One of them said, we've always taught that you had to have an initial earnest money deposit, but that isn't the consideration. So it really isn't, but the buyer has no skin in the game. So having said all of that, we used to believe that we could only trust that there was really a deposit and a real buyer if there was a check. That started changing as wiring of funds got to be more common. And at least in the state of California, where you have to log every check you touch, we were like, we don't want to have our hands on the checks because the largest number of complaints against brokers in the state of California is a trust fund violation. So you'll see things that start to come, even though the law isn't the same, you'll see things that waft from state to state because our leadership goes and meets together at NAR and they start telling stories and agents move from place to place, and you'll start to see things shift and change because somebody else had a better idea. So we can get caught up in form over substance. The bottom line is you need to have money in the escrow if the contract says there has to be earnest money. And it's not that big of a deal how it gets there. It's more of a deal that it gets there.
Yeah,
And
got
it's
it.
good fun.
But I like that background information, Lisa, as to why checks were needed before, because when I started in this business, like, okay, I guess every time I write an offer, I have to grab a check. And I grab the check and I'd staple it to my appendix file, stick it in my drawer. Like, it's kind of weird, but whatever, that's what everybody does.
Yeah, and that's the thing I think we miss is we used to all carry dual files. Our offices had paper files.
Paper files.
And we had book boxes, or what do they call them? Banker's boxes. And we all paid lots and lots of money as a brokerage firm to store these banker's boxes in a warehouse somewhere. Well,
Yeah.
imagine with, silverfish and cockroaches in Hawaii. I can remember at my house with my mom being a broker, having boxes and boxes in the closets. And in California, I'd have to go through every so often and dump and shred.
Oh,
So,
gosh.
then we got to electronic storage for brokerage offices. I always kept a file personally until the technology has changed. So do you remember, and Kent, you may still do this, the categorization files, the 5 category Pentaflex files that have the
Oh,
little.
yeah. I know what you're talking about. I don't use them though, but yeah, I know what you're talking
Yeah,
about.
so years ago, that's what we would give a client at closing, was these divided things that have all of your inspections in one section, all of your contractual documents in another, all of your disclosures in another, and all of the sort of like escrow and preliminary in another. And you'd sit there punching holes or having your TM punch holes and create these file folders for you and your client all the way through escrow. We
Wow.
don't do that anymore. We do it all digitally, but I think one of the missed opportunities is making sure at close of escrow that your client has a copy of everything, either on a thumb drive or some other means of a Dropbox or something. And then following up with them and making sure they have a copy of all their paperwork when they go to file taxes.
Okay, perfect. All right, moving on, section C. I'll have you read section C.
Section C, offer to buy and purchase price. C1, offer to buy. Buyer offers to buy the property described below on the terms and conditions contained in the purchase contract. The purchase contract shall be binding if accepted by seller or not before. Date, time, AM, PM.
Okay, stop there. So you write up the offer, you submit it over to the seller, and it expires tomorrow. You don't get a response from the seller tomorrow. We get a response from the seller on Saturday. Saturday, they have a counteroffer to you with an expiration of Sunday. But this contract already offered to accept passed, right? Because they didn't get back to you by 5 p.m. tomorrow, as you wrote in this. But you received a counter that expires on Sunday. How does that work?
Well, if you
That means this one
accept
is, this one is void.
Not void, but
accept the counter, then that's like automatically accepting that you're okay with this being expired. Or not expired, but like, you're, once you accept the counter, that's like okay. then
Can you write it?
Past that.
Handwritten?
page 1. Right? Contract, let's see. Handwritten or type provisions, purchase contracts, supersede any printed provisions if there's a conflict. Maybe not exactly, but whenever the counter is, it changes this contract. It's kind of like section Q, right? So on there, it has a different expiration date. So sometimes people ask me about that, hey, if this expired, then what do I do? So, well, if they're going to counter you, it has a new expiration date. Well, what happens if I counter the counter? Well, then that will have a different expiration date. So this will still be there, but the counter will change that expiration.
But what if it's already, the deadline already passed, you can default, right? If you wanted to not accept it.
Oh yeah, I mean, if
Or I guess.
If there was no counter, then
Yeah.
then it's done.
Yeah.
Yeah.
Right.
The only way that it would be allowed is either you write another contract with a new date, or, I don't know how strict our brokers are. If they allow it, you might be able to scratch it and write it in or something, an initial.
I think people are doing a lot of, approval by email, which really isn't the best way you can do this. By the way, we have the forms in the KW library on the intranet, where it's either the buyer or the seller is extending their time frame for response of either their offer or counter offer. And that's the best practice. If it's expiring, do that. If you're
Oh, so wait,
accepting it,
Lisa, are you saying that some guys are extending by email and not on the contract?
yeah,
Oh, no, that I wouldn't like that.
I wouldn't like that either. So, do it the right way. If the other side says we're not going to be able to respond to you, would you please extend it? Is it legally acceptable for you to say on behalf of my client, we're extending it? Yeah, technically it is, because your client is responsible for your actions, but you become responsible if you're not acting in accordance with their instructions. So that means you want to have some steps to prove it. So the right way of doing this is go into the KW library, get the form signed by your client, and send it over to the agent. The other way to do it is go ahead and counter offer it. And
Yeah.
that way, when the other party signs it,
Yeah,
you're good.
it's just clearer.
Yep.
It's just you have problems when it's not clear, right? When one guy thinks one thing and the other guy thinks something else, and that whatever that is, it's important. But then you have two different interpretations. That's when you have problems.
My favorite, one of my favorite real estate attorney friends in California owns a company called Broker Risk Management, and he consults with brokerage firms with over 8,000 agents in them. And I love the story he tells. He says, when you get to the point of having to hire an attorney to determine who's right and who's wrong because of the actions of the agent, he says, just imagine two attorneys toe to toe ripping up your $100 bills as fast as they can.
Yeah.
So you don't ever
Yeah.
want to have an attorney have to interpret your wording or your actions. And there's an act of law or a part in terms of how arbitrators and judges determine how to interpret a contract. And you heard at the beginning when Kent was going over this, you go from pre-printed to anything that's typed in, changed, or handwritten. And then if there's still a lack of clarity in the terms, there's this thing called the scribe rule. And that means that the interpretation of the meaning of the contractual clause is going to go against the scribe of the instrument, the writer of the instrument. So if you're the person that wrote the language and you created the controversy in doing so, you're going to lose your power in the argument, according to how a judge or an arbiter is going to look at this. So that's why we don't want you guys creating, or even me, we don't want to create a lot of legal language when we're not attorneys. And one of the agents on this call and I had a conversation about this yesterday, where we had very simple language and their client wanted to reference every purchase contract clause that possibly could apply. As that's dangerous. You start interpreting the contract and restating it, you can end up making mistakes that come back to haunt you. Otherwise, we have to say, go get this reviewed by an attorney. So don't play attorney, keep it simple, make sure the broker reviews it, because you don't want to be the scribe of the instrument that has your clients suffer as a result of the lack of understanding that you create.
Perfect. Yeah. So if you're ever tempted to want to play attorney or engineer or accountant, read Section R. Section R tells you who you are and tells you who you're not. So just be aware of that, right? You're not going to play doctor. You're not going to try and diagnose somebody who looks like they're terminally ill because you're not qualified to do that. Same concept. You can't give legal advice. You can't give tax advice because you're not an attorney. You're not a tax person. So don't play that. Yeah. Okay, let's take how much time do you guys want? 5-minute or 10-minute break? What's a reasonable time frame for C1? It depends. It depends. If you're trying to force an acceptance before Sunday open house, then maybe it expires before Sunday open house. If you're trying to give them time because you want to appear that you're really nice, then give them 2 or 3 days, right? So Reasonable, I would say 2 days, that'd be for me, but everyone's different.
If they have like in the agent remarks offers due and gonna be reviewed on this day,
Yeah.
would you still try to be strategic sometimes and push it, or would you just go by that?
Oh, yeah, I mean, there are agents that even though there's a deadline, they'll submit because technically you're supposed to, anytime you receive an offer, you're supposed to present, right? And so they'll try and go, okay, well, I know it's due on Monday, but I'm going to submit today and it's going to expire on Friday and it's tomorrow and it's going to be a really good offer. But I'm going to force you to get back to me because I don't want to compete. So they'll say, okay, all cash above asking or at asking, whatever. Respond by Friday, even though offers are due on Monday. So that could be very strategic, right? Some agents and sellers will bend to that request. Some agents and sellers will say, nope, I'm going to wait. Just depends. Okay, so what, you guys want 5 or 10-minute break? It's 2:05 right now. 10? Okay, 2:15. We'll be back. Thanks, Lisa. We're going to just take a quick break.
Perfect. Me too. Thanks.
It's 2:08.
Yep.
Well, that says 2:02. That's 2 minutes off.
There it is.
Cool. Okay, we're gonna get started again. We got through. See, I promised you it would take longer than you would think, because we're only on section
Yeah.
C2. You guys are slow.
What did I get myself into?
So that's why we were talking earlier about if this class is successful after like 3 sessions, if people are showing up. But if no one's here, okay, have we finished section C?
C2, purchase price. The purchase price for the property in the US dollars shall be paid as follows. Initial earnest money deposit. Additional deposit paid into escrow by balance of paid down payment or balance of purchase price in all cash. Paid into escrow prior to closing. Total cash funds from buyer, exclusive of closing costs, by way of total purchase price. Should buyer fail to make the initial earnest money deposit or additional deposit when due, seller may elect to terminate this purchase contract pursuant to paragraph 021.
Okay, thank you. So pretty straightforward, right? You're gonna write down what you're gonna offer. So in your initial deposit, your additional deposit, and that you're gonna say when you're gonna deposit it into escrow by. Typically, it's gonna be 2 business days after J1 acceptance, something like that. Balance of the down payment, total cash, whatever you're gonna finance, it'll be by way of, first and or second mortgage at prevailing rates and terms, or something of that sort. And then your total offer price. So this is where you're talking to the buyer about what the initial is, what the additional is, the cash, and you're asking them, do you have the cash? Right? Do you have the cash to buy this for the down payments and all that? And then hopefully you've already had your buyer talk to a lender who you know and trust, and that they're qualified, so that it all lines up. The lender might also be able to verify cash for the buyer. And then you fill out the rest, and that's what they're going to be offering. So that bottom section, I always point out to both buyer and seller that it's important that you make these deposits on time, because if you're late, it says that you can terminate section pursuant to 01, and 01 is default. So 01 is bad. Anytime you see 01, it's bad. Somebody is not doing what they're supposed to do. Okay, so if it's 01, seller can cancel on buyer. And if it's the additional deposit, they can cancel and keep the initial deposit. Okay. And for buyers to understand that this contract heavily favors you as a buyer, you have more rights in terms of being able to get out than the seller does. But one of the few ways that the seller can get you is if you don't make your deposits. That's one of the few ways that the seller can get you. So pay attention, right? Get your deposits in when you need to get it in. So that's why your buyer needs to know when you're in escrow, when you get accepted, get your money in. When you pass J1, get your money in. Especially in a hot market, if it's a flat or a bad market and you're the only offer on the table, then the seller's not going to cancel on you if you miss a deposit, because I'd rather have somebody I can work with than nobody. But in a market where you're going 50, 100, 150 over asking, it's possible, right? They might cancel on you because you missed $1,000 deposit, whatever. Yeah.
Is additional deposit often?
Oh yeah, I see it as standard, but I mean, I guess you could. It's just, yeah, I would say most common is additional. I rarely ever see no additional deposit.
But what do you base it on?
Everyone has a different take on it, but
It's
it'd
just
be like,
what the seller wants.
percent, right? Everyone, there's like a general rule of thumb, it's like 1% or 2% of purchase price,
For
depending.
the entire deposit or to addition?
So the first might be 5,000. So let's say it's $1 million property, right? So you might go, okay, I'll go, what, 1%, 10,000, maybe something like that. You know, it's what you're trying to do is to show seller that you've got skin in the game and you're willing to risk that. If there's a default, that's because that's the risk for the buyer. If they become in default, then they risk losing the deposits.
And additional is generally after J1.
Yes, yes. And so you put in there, the key is you put it in there, and I'm sure the brokers will see that if you don't do it right, although don't count on that. I would always make sure you do it the right way. But normally like 2 business days after J1 acceptance, and make sure it's business days. Because you run into this problem of if you don't say business days and J1 expires on a Friday, and let's just say that you put two days after J1, that means it falls on a Sunday. Right? So Tony and I, we were involved in one a long time ago where we were the sellers. We canceled on the buyer because they didn't get their additional deposit in on time. So we canceled, and we were talking back and forth about, well, it fell on a weekend. So Tony goes, let it go till Tuesday, then cancel. Even though we could have canceled on Monday, he said, let it go till Tuesday because it fell on a Sunday, right? So don't put your buyer in that situation where it's gray. Remember we talked earlier about it being gray? Try to have clarity. Remember that, Tony?
Yeah, that's the reason why we changed that verbiage in the contract.
Not because of me. Okay.
Take credit.
Thank you. Okay, I'm sorry, I don't. Okay, you can do D
Addenda.
and just rip through the whole thing.
Okay, addenda. The following addenda, if checked, are attached to and made a part of this purchase contract. Fill in all blanks. Write NA if not applicable. Each attached addendum must be properly signed and initialed as applicable. Ready? 1031 exchange, agreement of sale, as is condition, distressed property, dual agency consent, early occupancy agreement, FHA financing, real estate certification, lead-based paint disclosure, oceanfront property, plain language, post-closing occupancy contract, purchase money mortgage, residential leasehold property, short sale, VA financing, other.
Okay, so, just know that, as we said earlier, right? To make it a part of the contract, you got to check it. Also, they want to make sure that for clarity's sake, if it doesn't apply, put an NA next to it. Don't leave it blank. A lot of them, if it's an old home, you're going to have things standard like lead-based paint. Some on the listing on the MLS will say we're selling it as is, so include the as is addendum. I mean, they're not telling you have to have it. They're telling you they want it. And if you don't do it, they may ding you for it, right? And then the other, that's where you can put in the KW standard addendum or any of the other addendums that may not be listed here. Okay. Go ahead. You can finish. Well, E is just a description, right? You're going to put in tax map, which should have transferred from the first page. So that's why I'm always going to try and make sure that I confirm my tax map information. You're going to check off if it's fee simple or leasehold. And then we have what I think is a kind of a standard way of describing what it is that is being purchased. So things that we tend to stay away from would be specifics like maintenance fees, property taxes, size of the home, size of the lot, because those things could change, right? So we tend not to include those things in there. Okay, and then on the bottom it says full legal description will be provided in the title report. Okay, who's back there on that? Okay, hi, just read E2, don't have to read all the pieces, just read the top, paragraph there.
E2 inclusions, sale includes all built-in furniture attached to existing fixtures, built-in appliances, electrical, gas and plumbing fixtures / systems, attached carpeting, and the following indicated items. Seller shall not substitute any inclusions, fill in all blanks, write and pay if not applicable.
Okay, makes sense, right? So everything attached, everything built in goes with the home. If it's not built in, and let's say that your buyer wants something and it's not built in, I would recommend you put it in there somewhere that's going to be sold with the property. Again, clarity. Okay, why don't you read the top of E3? Oh, any questions on that, first of all, E2? No? Okay.
Well, I just have one little question. It's about the microwave hood.
Yeah.
And then the solar water heating system
Okay.
and the water heater. So particularly when you check solar water heating system, that includes the water heater and the panels on the roof for the water heater.
Yeah.
So no need to check water heaters separately. And if you do, that implies that you have 2 water heaters in the house. And you could be paying for 2 water heaters. And
Seller could be having to provide 2 water heaters.
yes, okay.
Yeah.
Thank you.
Any comments on that, Tony?
No, I mean, some houses.
2? Yeah. I mean, sometimes it gets a little confusing too, right? Because you have like range hood and microwave hood and
So for the other part of my question with microwave hood, should you just not check microwave and then check other microwave hood to be more specific?
Yeah.
Maybe just microwave hood.
Some have those integrated hoods, right? The microwave and then the fan underneath
What if it
versus,
has microwave and no fan? Or no fan that fans out?
I'm sorry, you have a, yeah, if it had no fan,
And it has a fan, but it's not a fan that vents out.
I think that's still considered a microwave hood.
Yeah.
Hood, yeah.
It is.
Yeah, because it just filters. It doesn't take the air out. It just filters the air and tries to trap the grease in that filter. So it just circulates it, but it sucks it in and then tries to catch the grease and then sends out the air. Okay. E3, why don't you read E3?
E3, inclusions of photovoltaic system and or security alarm systems, contracts and leases. Sellers shall provide applicable documents, including most recent statements with any of the following. Lease photovoltaic system, lease alarm system, other, and energy purchase photovoltaic agreements. What is that?
Okay, so there's all these different, for photovoltaic, right? There are different systems out there depending on when it was installed and what was available at the time of the installation. So early on, there were photovoltaic systems that you could buy, put on your roof, and get a tax credit back from the state and the federal government. And on top of that, whatever was produced was called a NEM, net energy metering agreement, right? Whatever you consume at, so whatever you pay per kilowatt would be the same amount that they would give to you if you produce more than you consumed. So you put it back on the grid at the same amount price-wise or cost-wise as you would consume. Then HECO knew that at some point it would oversaturate, so they changed it. So they said, okay, well, you consume at a higher rate, I'll give you money back, but I'm going to give you money back at a lower rate. That went on for a little while. Then after that, it was, you can put up PV, but then you have to put up your own batteries. You can't, I'm not gonna allow you to put it back on the grid anymore because it's gonna fry the grid. So that's what we have now. In addition to that, you had companies that would put up a system, mainly with the first, I think, agreement, the NEM, where they would say, basically, let me lease your rooftop. I'm gonna put up a PV system and I'm gonna set a rate for you. So I'll produce electricity and I'll sell it to you at this rate, which is lower than what the HECO rate is. But for that, they can use a roof and this is the term, right? Whatever the term is. At the end of it, either you buy it out or you have them remove it. So in here, it's just clarity. What is it that comes with the house? Is it an owned system? Is it a lease system? What's the agreement with the system? And it can get tricky. So if you're buying one, I would make sure you get all the documentation on the leased photovoltaic or leased alarm system, whatever it is, because a lot of those systems, like PV as an example, will run with the house. So it transfers to the new owner, that responsibility. So if the buyer's unaware of it and they get stuck with that later, they're gonna be looking at you going, what happened with this? Right? So understand that. Okay, why don't you continue that section?
Seller shall provide documents indicated above to buyer and notify service providers of this purchase contract no later than days after the acceptance date. Upon receipt of the documents provided, buyer shall have 8 days to terminate this purchase contract pursuant to paragraph 02.
Yep.
If buyer does not terminate, buyer shall apply for a transfer of service within 3 business days after buyer's approval of documents.
Okay. So, this is just to make sure that buyer is aware of what it is that they're going to be taking on, have the ability to review the documents and accept them, or cancel the contract if they don't like what it says, right? So that's what all these things say. And O2 is within that time frame. So if it says, I need the documents within, 5 days after acceptance, and then upon receipt of the documents, I have 15 days to terminate the purchase contract. If I don't like it, then know that you have 15 days. And if you don't cancel within that 15-day time frame for this specific provision, then you accept it. Okay. Any questions on that? Yeah, Tony.
Also, if the buyer is assuming the lease, they have to qualify for it.
So the lease company then will do their own due diligence to qualify the buyer. Okay. I've done it on the sales side. I haven't done it on the buy side. Okay. On the sales side, we did have to notify them and work out all the details and. Okay. So you guys all got that, right? If there's a lease involved, the buyer has to qualify. So in addition to whatever they're qualifying for on the house, I guess the PV company will do their own credit checks and all that to make sure that the buyer can afford to pay it. Okay, you want to read E4 for us?
Sure. Inclusion of furnishings. Inventory of furnishings is attached to be provided to buyer by date. If seller does not provide the inventory list to buyer within the specified time period, buyer may elect to terminate this purchase contract pursuant to paragraph 03. If buyer is not satisfied with the inventory list, buyer may elect within blank days after receipt of the inventory list to terminate this purchase contract pursuant to paragraph 02.
02, okay. So you guys are hearing 02, 01, 03, right? So know that 02 is within that time frame. Whenever you see 02, it's got to be within those 5 days or 10 days or 15 days, whatever that review period is. If you're going to cancel because of that provision, you got to do it within that time frame. Okay, so that's what 02 is. Inclusion of furnishings. So, Tony, maybe you can help here. Whenever we do a transaction, we try not to include furnishings. and we'll do it outside of escrow, right? Is that still, how do you explain that to buyers and sellers as to why?
If you're doing like financing, a lot of times you may put some value on the furniture. That's the loan. Buy this one little furniture in there. It's I'll be described as having to do all the furniture. Otherwise, if the seller have to go ahead and get it out.
So it could affect the loan then.
Especially if we have a VA and FHA.
Yeah.
So that's why, like, back in the day, we used to put, furnishings are included in the sale and have no value.
Yeah, yeah. Okay, so, yeah, on the furnishings, normally it's, you write it up as handled outside of escrow and you maybe have a list for it. And I think the point is, if a lender's involved, they may want to try and place a value on it, which may affect the loan.
Yeah. But then, if you're buying a condo tower, and they do from furnished, the condo tower will be paid for by cash, so.
Yeah.
Take photos of the furnishings and not like a line item, because they can spot stuff out.
Good point.
I have a
Yeah.
question.
Yeah.
I saw on a home, they said furniture partial. And so I asked what furniture would be included, and they said refrigerator and washer and dryer, even though it was checked off in exclusions. Is that common to see those?
I don't think they filled it out right, because normally that would be part of, instead of saying partially furnished, I don't know why they said that, but that would be part of the inclusions of MLS where you'd say what's included in sale, washer, dryer, yeah.
Right.
It's a Hawaii thing, you know?
And
like,
was it an EXP?
No.
I'm just curious if it's a broker thing, like.
Yeah.
That was,
Yeah.
but yeah, I thought that was interesting.
Yeah, I don't think so. Okay. So E-5 exclusions, right? So that's again where, let's say the seller wants to keep something. And let's say that customarily you'd include the washer dryer. But they go, you know what, it's brand new or it's sentimental to the family because my brother gave it to me. You check that off and make sure you include it in there as an exclusion. Okay, closing.
Section F, closing, F1 closing, purposes of this purchase contract, closing shall be the date when all appropriate conveyance documents are recorded in the Bureau of Conveyances of the state of Hawaii. The Bureau of Conveyance. Why are they doing that?
Okay, so closing for, because there's all this different terminology, right? So closing for us means that that's the date that the Bureau will record everything. And so let's say that our close date is, what is today? 14. So let's say our close date is the 15th. Everything, all the money and all the documents, everything's all ready. Escrow is going to be sending that stuff over to the Bureau. And the Bureau, by this time today, if it's closing tomorrow, it's gonna close. It's gonna record tomorrow. So that's when all the documents, it becomes official. Money goes to the seller, ownership goes to the buyer, and that's what closing is for us. So closing date, you'll put down a closing date there. Some will put a hard date. Some will say 45 days after acceptance, whatever it may be. So if you're going to put anything other than 45 days, or even if it is 45 days, always check with the lender, make sure that there's a loan involved, that they can support that closing date. Yeah.
So for 45 days, you count, the first day is like the day after acceptance?
Yeah, so you count from the date, the next day. Yeah. On the lending side, I've heard it from banks before where, we all see 45 days as kind of the standard, right? If I've got a loan officer, I'm telling them we're closing in 45 days, and that's acceptable. I've heard a bank tell me before, oh, I need 55 days. So just be aware, just because we all know that 45 days should be the most time that you need to close, some may want more. And flip side of that, there are lenders that close in 30 days. And they look at that as, yeah, no problem, 30 days can close. So I think it's all based on their systems and how they go through underwriting and how they go through loan approval process and all that. So with regard to closing date, the lender plays a big role in making sure that that date can be met. Right?
And you can say 45 days or less.
Yeah, so if it goes 45 days, and I'm cheating because I didn't read it yet, but if it goes 45 days and that 45th day ends on a Saturday or a Sunday or a holiday, then what is the closing date?
That beats the next business day.
Perfect. Next business day. When would it be prior to that? Or sooner, yeah, or less, yeah, whatever, yeah. So you gotta make sure that you specify that. Otherwise, you may think one thing and tell your client one thing, which may not be right. So you need to understand. If you say 45 days and it falls on a weekend or a holiday, it's gonna be the next day. And it says it in here, right? Scheduled closing date shall be whatever. If the scheduled closing date falls on a day the Bureau of Conveyance is closed, closing will be on the next day when the conveyance documents can be recorded. So it could be a federal holiday, but the state's open, it'll record. Okay. I'll be doing it in time. So we'll go for 5 more minutes and then we'll just have a 10-minute wrap up and then we'll continue the next session. So we are at F3. Okay, change to scheduled closing date. So this choose paragraph F3A or F3B. Remember earlier I said there are sections that says one or the other. So this is one of them, example. So choose F3A or F3B. A, one-time unilateral right to extend. Either party may extend the scheduled closing date up to X days by delivery of written notice to the other party prior to the scheduled closing date. Once either party has exercised this unilateral right to extend for all or any part of the extension period set forth above, time shall be of the essence, and there shall be no further unilateral right to extend by either party. Okay, so what it's saying is, this is a one-time extension. Either party can request it, but there's only one. So in other words, if I'm the buyer and I say, oh, I need a 10-day extension, the seller cannot go, okay, I'll give you that. And then, oh, I want a 10-day extension as well. There's only one. Can you extend it beyond that? Yeah, you can if both parties agree. Okay. If both parties don't agree, then time is of the essence after that 10th day or up to that 10th day. The scheduled closing date should not be further extended unless buyer and seller agree in writing. This provision relates to the extension of the scheduled closing date, and time frames measured from the scheduled closing date shall be measured from the extended scheduled closing date. You guys get that? A little confusing? Okay, so this provision relates to the extension of the scheduled closing date. Okay, so 45 days, which would be December 31st. And timeframes measured from the scheduled closing date shall be measured from the extended scheduled closing date. So what it's saying is, if you have like termite as an example, and termite is normally 15 days prior to close, seller delivers termite inspection report. But instead of it closing on, day 15, it's a 10-day extension, so it goes to day 25. So now instead of it being termite being due on the 1st, now it's due on the 10th, right? So whatever's tied to the scheduled closing date, if it was due based on the closing date being pushed out, then that provision will also be pushed out. Okay, and then so that's if there's an extension. So you can either say, yes, I want the right to have an extension by going F3A. Or if some sellers are like, no, I gotta close within whatever days, then they would check B or counter you and check and B be checked, which is time is of the essence, no extensions.
Question,
Okay, so be one or the other. Yeah,
F3, and let's say you say 10 days in the purchase contract.
yeah.
And you realize you have a termite or you have something that you're gonna need more time than 10 days. Okay? You're gonna.
You need more time for what?
More time than the F3 allows for, you're saying an F3 up to like 10 days, right?
To schedule the termite inspection or?
Well, just in regards to the F3 section, you're saying either party may extend up to, let's say you put 10 days,
Yeah.
and then that's agreed upon.
Yeah.
You know, you find out you need 15, you need 18. Not uncommon, we have lots of new agents and you're just excited about the deal, your first transaction, you write an F3 and you put 18 days because you know you need that. How does that affect the purchase contract and where you are in regards to getting an extension? Can you write an F3 with longer than the 10 days of what the purchase contract says, and what's the ramification?
Okay, so several questions that you answered. One is, if it's already written as 10 days, that's what it is. If you need it to be longer, then you got to negotiate with the other side. Right? So if you need 18, but it says 10, then either you're going to change your F2 and leave F3A, because F3A is still the 10 days.
I can share an example of this since I did it right now.
Yeah, go for it.
Okay, so my real life example looks like this. Mine is 10 days.
Yep.
My client needed to extend closing because of what the seller actually did. We extended closing from October 25th to November 4th. So we used 10 days,
Okay,
but we kept
F3A.
F3A
Yep.
in play.
Yep.
So either side still has the
Yep.
opportunity to extend for 10 days if we need it.
Yeah, no, that's what I was saying that.
So one of the difficulties with this is that we have heard and discussed it before, that one side could burn it.
Yep.
And then you don't have that, then you're forced to renegotiate.
Well, when you say burn it, right? If somebody uses it and I didn't need it, then normally that the extension is happening kind of later in the process. So if it's happening kind of later in the transaction, then you kind of know that your ducks are in alignment and you don't really need the 10 days. But if they've got to take it, we're ready. Take it because you have the right to, but we're ready to close. Now, if something happens that says, oh, shoots, now not only do you need 10, I need 10 too, then something major has happened in that process. And so, yeah, you at that point would be negotiating with the other side going, you took the 10, great, I need a little bit more time too, because this thing just happened to me. And then it'll be negotiating that.
In my situation, actually, so the seller wanted to extend the.
Yep. Okay.
He wanted to lease back, but my buyers, lenders, they said they cannot.
Okay.
They basically, the only they can have is 7 days.
Okay.
Not a month.
Okay.
So is it also like you have to discuss with the lender?
Oh, yeah. You know why probably the lender doesn't want to extend? Probably because of a loan lock. Because they got to fund.
Okay, that's what he said.
And if they don't fund, then that means that the buyer is going to have to pay a penalty to extend it or pay a higher interest rate, right? So yeah, going back to F3 or F2 and F3, if there's a need for more time, and let's say you want to preserve F3A, then what you do is you don't talk about F3A. You say, I want to extend closing. Don't even mention F3A. And say, I want 10 more days on F2. And then hopefully they're like, sure, no problem. I'll extend F2, but it does nothing to F3A. So F3A still applies.
So if you say,
Whatever your F3A
if
is.
you misstate the date and you say 15 when you only had 10, do you, and I like the term because it's like playing cards. Do you
Yeah.
burn it in essence by throwing it out there with the wrong date or number of days, does that burn F3?
Try that again. If you do what?
So let's say you have 10 days for the purchase contract,
F3A is 10 days, yes.
but you know that it's actually you needed 15. So you kind of, in the rush to write something and get the extension, you put 15 days on the F3.
Oh, no, it doesn't say that. On the extension, it'll be either F3A or, yeah, so I don't remember it offhand clearly, but I believe it says there's two sections, right?
Yes.
F2 or F3A, and F3A, does it have a amount of days? Or does it just say
Yeah,
F3?
yeah, and then,
Or it does have the
and
days?
then it also has the date line, we can
Yeah.
put the date.
So an agent had filled in more days than they.
Oh, that's a good question. And then what happened?
We wanted to be safe and to cover, we treated it as that being burned. So whether or not Lisa, and that's right, we wanted to err on the side of caution and use an F2, right? Though, and not to mischaracterize, I said new agents and you're excited. Agents that have been in the game in a long time, they have 10 days, they took an F3 and they took it 5 days.
Yes.
And then come.
Yeah, but that's earlier though.
Come
That's-
back and they go, oh, let's write another one for 5 days.
Right. But it's unilateral,
And how many times?
only one time usage.
Yeah, I don't,
That's what we're talking about burning it.
but I wouldn't ever say F3A, I only need 5. I would say I need F3A, the full amount that's on the contract.
You mean upfront, yeah?
Yeah, because every escrow knows that if there's an extension, it doesn't have to go the full 10. If people are ready to close earlier than the 10, escrow knows close. They don't need any more documentation. That's what I've been told by escrow. But if you want to go beyond that, then yeah, they need documentation for that.
It's a tricky one. when it comes
Yeah, I
to
don't,
cars.
Lisa, are you still there?
Dates.
I know.
I am still here.
Yeah, because Kerry, he's very tricky and devious. So he's asking me all these questions, trying to stump me. And he did. So what his question is on the extension form, right? You can check off F2 or use F3. And this is not on the contract itself, but it's on the extension form that
Right.
you're going to use to extend. What he's saying is, I've written the contract for 10-day F3A. That's what's on the contract. But when I send the amendment over, I not only check off F3, but I fill in the blank with 15 days. And I have the buyer sign it and I send it over to the seller. But clearly the contract says 10. What happens?
Okay, well, wait a second. First of all, if you're using the unilateral,
Yes.
it's at the bottom of the form and it doesn't
Yeah.
require a seller signature.
Yeah,
Therefore, if you try to say more the days than what was in the contract,
yeah.
that you can enforce the extra days.
You
Because
cannot.
it's You cannot because it's unilateral.
Okay, so that's the answer. So that's the answer. Because maybe it's just if you want to shorten it, but yeah, you cannot extend it because you already said 10 days on the contract.
It's
Yeah,
a
and so remember the scribe rule, right? And I cannot say, let me emphasize, cannot say what an attorney would argue. And my definition of this is they will argue at $400 an hour, whatever you want them to argue. But I would even say that I wouldn't want to be in a position to have a 10-day unilateral and then write in 15 days at the bottom of that form. Because then what could happen? They may not be right, but the seller could say, no, that's void because it was done improperly. And I'm giving you a 1-day extension, thereby extinguishing your other 9 days.
That's what I'm talking about, burning it.
Yeah, and it burns it. And we had a situation where I'm trying to think if the person is on this call. She is on this call. She had kind of she or he, okay, she.
Doesn't matter.
Sorry for calling you out, Audrey.
I knew it was Audrey. I was gonna use Audrey too, but I held back.
Yeah, so Audrey had a client that was rather difficult and thought he was smarter than everybody. And he went out to a property and he went before the property inspection and unplugged all of the ring devices for the seller so that they wouldn't be able to eavesdrop on his property inspections. And what ended up happening is the buyer wasn't able to perform on some of their requirements in an acceptable time frame. And the seller was so mad at the buyer that she wanted to bounce him. This poor Audrey door knocked to get this sale. And what the seller, who was also an agent, did is just gave them a 1-day unilateral right to extend. And because their timeframes for loan approval were relative to the close of escrow, they were then able to cancel on the buyer because he couldn't perform on his conditional and final loan approval. And so it ended up costing the buyer the transaction because he was being a jerk.
Now I understand the question. I didn't understand it earlier. So the other side took it.
Yep.
But they took less than the 10. Now I got it.
And by the way,
Oh.
I just did that in escrow now, and I did it because
Tricky.
my client wants to move in sooner. Our day landed on, so our day for closing landed on a Monday. My guy works a Monday through Friday job. He wants to move on the weekend. So what we did is we said, let's go ahead and take the unilateral for 4 days, moving it to Friday. That way he only has to pay interest on his 2-day good funds of the money coming into escrow. Because otherwise he would have had to fund it. Friday was a holiday, so he would have had to fund his loan on Thursday. I'm sorry, he would have had to fund his loan on Wednesday of last week and paid for interest Wednesday, Thursday, Friday, Saturday, Sunday to record on Monday. And then he wouldn't have been able to move into his house until Saturday after, from work. And he would have paid for a lot of extra interest. And he's very, it's a low end property. So what we did, as soon as we calculated the days to a close on Monday, we took our 10-day unilateral and we asked for 4 days. So we would close at the latest on Thursday. We said 4 days or sooner if at all possible. And we close tomorrow and he can move in on Saturday. But he didn't want the buyer or the seller to have more days because that would have moved him into yet another week. If he wants to get moved in. So, it's not just burning it, it's about being strategic, but knowing what all the moving parts are. This is why we do these classes, because this is the magic where we started this at the beginning of the conversation. If you really know the contract and the moving parts, you can put your client in a better position, or you can be at the whim of the party that knows it better.
Yep, absolutely. So along that note, Lisa, there's a Better Homes addendum, which in there it says that if one party uses F3A, but only uses a part of it, the other party can use the remaining part of it.
Yes. So we tend to at least have that discussion and say, do you want to remove it?
No, what I'm saying is if this, I think it should go back to the HBR contract team to say, they should just defer to whatever it says in F3A is your time frame, because anyway, it's a separate conversation.
But thanks for asking. I mean, it's not too often we get Lisa and Kent's line on this thing, so I know we all need to take a breath and let our mind settle from that. But going back to the point of the whole thing is understand the contract.
Understand the contract, yeah. So anyway, we're out of time. We got to section F3, and this has been 2 hours, and we're on page 3. Unfortunately, it takes time to understand it. So that's just the nature of this kind of class. So we'll continue it. Hopefully you guys see value in it, and that you can learn and you can become better agents and better represent your clients. So thank you for your time today. Any questions? Any other questions? Okay, we can go offline with that. But anyway, we'll let the Zoom guys go. Thank you for attending.